The highest court in America just issued a ruling so powerful that every single justice agreed, and it's about to transform gun rights across every state in ways most people haven't realized yet. This verdict isn't simply another courtroom headline destined to vanish within days. We're witnessing a constitutional transformation that's already compelling judges nationwide to reverse prior rulings and sending state lawmakers into emergency strategy sessions. The principles established here will shape outcomes for every firearms owner in America, everyone contemplating their first purchase, and every municipality wrestling with how to protect citizens while honoring constitutional freedoms. If understanding the future direction of firearms legislation matters to you, what I'm revealing next will fundamentally alter your perspective on every gun debate moving forward. The landmark verdict that reshapes everything. United States versus Raheem has emerged as the most consequential firearms rights case since the historic Bruin ruling arrived 2 years earlier, and its effects are cascading through legal chambers nationwide right now. The justices confronted what appeared to be a straightforward question: may authorities temporarily prohibit firearm possession for individuals deemed credible threats of physical harm toward others? Their response was definitively affirmative, but the judicial reasoning underlying that conclusion creates this decision's extraordinary significance. Consider this carefully. Every single justice concurred. During an epoch when our highest court fractures on virtually every major constitutional matter, all 9 members reached identical conclusions regarding Second Amendment application here. The court's most conservative voices stood united with its most progressive members, declaring collectively how constitutional firearms rights should be interpreted. Justice Clarence Thomas, architect of the groundbreaking Bruin framework establishing historical tradition analysis, endorsed this opinion. Justice Ketanji Brown Jackson, among the court's newest appointees, endorsed this opinion. America's complete ideological spectrum of legal thought converged on this ruling. When all 9 justices agree, the constitutional ground beneath us shifts permanently. Yet here's the critical insight most observers are overlooking. The court transcended deciding one individual's case under one particular restraining order type. They delivered a comprehensive analytical framework for evaluating every firearms regulation throughout America going forward. And that framework just resolved years of confusion paralyzing lower courts since Bruin's arrival. The framework receiving crystallization. 2 years prior, Bruin instructed courts to assess gun regulations through historical tradition lenses. Modern restrictions lacking clear historical parallels from America's founding period or Reconstruction era couldn't withstand constitutional examination. That standard seemed sufficiently clear, theoretically, yet practically it generated absolute pandemonium across federal courtrooms nationwide. Judges confronted impossible dilemmas. How closely must historical statutes resemble current ones to qualify as analogs? Should comparisons focus on specific regulatory mechanisms or broader underlying principles? What happens when founding-era circumstances had no equivalent to modern scenarios being addressed? This new unanimous ruling just answered those questions with remarkable precision. The Supreme Court clarified that judges should seek historical principles, not perfect historical duplicates. You needn't locate 18th century legislation matching modern regulations verbatim. What's required is evidence demonstrating your imposed restriction aligns with how the founding generation comprehended limits on bearing arms rights. The justices explained historical analysis should employ analogical reasoning, not rigid historical matching games, demanding every detail align flawlessly. Understanding why this matters profoundly right now. Dozens of firearms laws currently face federal court challenges, with judges issuing contradictory decisions because they lacked clarity on flexibility versus strictness when applying historical tradition tests. Some judges rejected any gun law without nearly identical historical precedent. Other judges stretched historical analogies so flexibly that virtually any restriction gained justification. This unanimous decision just provided every federal judge in America explicit guidance for navigating that middle territory. The court also clarified something even more foundational. The Second Amendment safeguards rights of law-abiding, responsible citizens to keep and bear arms. That final portion, the law-abiding responsible citizens language, just became Second Amendment jurisprudence's most critical phrase because it establishes that government may disqualify individuals whose conduct demonstrates they fall outside that category. The founding generation grasped this principle. They enacted laws disarming community threats. Loyalists during the Revolutionary War experienced weapon confiscation. People refusing loyalty oaths faced arms possession prohibitions. Historical tradition wasn't universal unlimited firearms rights regardless of conduct. Tradition recognized that responsible community members possessed that right. Implications for pending litigation. Presently, multiple federal courts have suspended cases awaiting precisely this Supreme Court guidance. Those cases will now resume with clear roadmaps for resolution. The consequences are materializing in real time. Within 48 hours following this decision's release, federal judges across 3 separate jurisdictions referenced it in fresh opinions. Legal foundations are shifting beneath active litigation as we speak. Yet here's what nobody's discussing yet. This unanimous ruling doesn't merely affect the specific statute at issue in Raheem. The framework established applies to every gun regulation category currently being challenged. Assault weapon prohibitions, magazine capacity restrictions, concealed carry limitations, waiting periods, purchase limits, and controversial red flag statutes allowing temporary firearm removal. Every single legal battle just received new evaluation rules. Assault weapon prohibitions confront their reckoning. 7 states currently defend assault weapon prohibitions targeting certain semi-automatic rifles based on features like pistol grips, folding stocks, and threaded barrels. This unanimous Supreme Court decision just complicated those defenses substantially. Illinois, California, New York, Connecticut, Massachusetts, Maryland, and New Jersey all passed legislation claiming so-called assault weapons possess unique dangers placing them outside Second Amendment coverage. But here's the predicament these states now face. Under the framework the Supreme Court just clarified, these prohibitions require historical tradition roots, and they must target conduct-removing individuals from law-abiding, responsible citizen categories. The AR-15 platform represents America's most commonly owned rifle. Over 20 million such firearms currently reside in civilian possession. That's not some fringe weapon or uncommon collector's piece. It's a common arm that millions of law-abiding Americans own for self-defense, hunting, sport shooting, and additional lawful purposes. The Supreme Court has repeatedly stated the Second Amendment protects arms in common use for lawful purposes. That principle was established in the Heller decision back in 2008, and this new unanimous ruling reinforced it by emphasizing the law-abiding responsible citizen standard. States defending assault weapon prohibitions have argued these firearms appear disproportionately in mass shootings and that military-style features render them unusually dangerous. But this new decision complicates that argument fundamentally. The question isn't whether firearms could potentially face misuse by criminally minded individuals. The question becomes whether law-abiding citizens possess constitutional rights to own that arm for lawful purposes. And if 20 million Americans own these rifles without incident, that's compelling evidence the weapon itself doesn't remove someone from responsible gun ownership categories. We're already witnessing courtroom movement. An Illinois federal judge recently expressed serious skepticism regarding that state's assault weapon prohibition during hearings, specifically referencing the need to apply clarified historical frameworks from this new Supreme Court decision. The Ninth Circuit currently considers California's ban, and plaintiffs there already filed supplemental briefs arguing the unanimous decision supports their position. Multiple legal scholars now predict at least some state-level assault weapon prohibitions won't survive the next appellate review round. But assault weapon prohibitions aren't the sole restriction category facing serious constitutional pressure currently. Magazine capacity. Restrictions on unstable ground. 9 states currently restrict magazine capacity to somewhere between 10 and 15 rounds. California, Colorado, Connecticut, Hawaii, Maryland, Massachusetts, New Jersey, New York, and Vermont all claim limiting magazine round counts will reduce mass shooting casualties. The theory is straightforward. If shooters must reload more frequently, bystanders gain more escape or intervention opportunities. But the constitutional problem with these statutes just became substantially more serious. There exists no historical tradition in America of restricting arms capacity that citizens could own. When the Second Amendment gained ratification, firearms technology obviously differed from today. But the founding generation didn't restrict capacity of arms that did exist. Multi-shot weapons existed in the 18th century. Repeating rifles existed. High-capacity firearms for that era existed, and there's zero evidence of colonial or early American statutes saying citizens could own firearms, but only if they held limited shot numbers. Under the framework the Supreme Court just clarified, that historical tradition absence creates major problems for these capacity restrictions. The justices made clear that modern gun statutes must align with how the founding generation understood bearing arms rights scope. And if the founding generation didn't restrict capacity, modern legislators will face extreme difficulty justifying why they can. Add to this the emphasis on law-abiding, responsible citizens. A person owning a 17-round magazine isn't automatically less law-abiding than someone owning 10 rounds. The magazine capacity doesn't determine possessor character or conduct. Millions of Americans own standard capacity magazines and never commit crimes with them. That's exactly the lawful use by responsible citizens that the Supreme Court just said the Second Amendment protects. Legal challenges to these magazine limits are already accelerating. The Duncan v. Bonta case in California has worked through the Ninth Circuit for years, bouncing between different panel decisions and en banc reviews. That case directly challenges California's 10-round limit, and it's now headed back to district court with instructions to reconsider under Bruin's framework. Except now, there's this new unanimous decision providing even greater clarity about framework application. Multiple Second Amendment advocates predict magazine capacity restrictions nationwide could fall within the next 18 months. Red flag statutes enter uncharted constitutional territory. 21 states have red flag statutes allowing firearms to be temporarily confiscated from individuals based on allegations they pose dangers to themselves or others. These statutes, also called extreme risk protection orders, let family members, law enforcement, or in some states even employers or school officials petition courts to remove someone's guns before that person has been charged with any crime. In many states, these orders can be issued initially without gun owners being present at hearings, meaning your firearms can be seized based on someone else's testimony before you have chances to contest allegations. This new unanimous Supreme Court decision doesn't directly address red flag statutes, but it establishes principles that will inevitably shape how courts evaluate them. The justices emphasize that the Second Amendment protects law-abiding, responsible citizens, and they upheld government's ability to disqualify people who demonstrate through their conduct that they pose credible threats. But here's the tension. Red flag statutes remove firearms based on predictions and allegations about future conduct, not based on actual criminal convictions or formal mental illness adjudications. The constitutional question becomes, what level of due process is required before government can temporarily strip someone of Second Amendment rights? The Supreme Court said government can disqualify people who aren't law-abiding and responsible, but red flag statutes operate in situations where persons haven't yet been proven dangerous through normal criminal justice processes. They're based on concerns, fears, and predictions rather than established facts. Several federal lawsuits challenging red flag statutes are currently active, and at least 4 have now cited this unanimous decision in recent filings. The argument being made is straightforward. If the Second Amendment protects law-abiding, responsible citizens, and if restrictions must be rooted in historical tradition, then red flag statutes need to provide robust procedural protections before firearms can be removed. That means prompt hearings with gun owners present, clear and convincing evidence standards, and strict time limits on how long firearms can be held without full adversarial proceedings. Some red flag statutes meet those standards, others don't. And the ones that don't are now facing serious constitutional challenges that this new Supreme Court decision just made more credible. This issue is almost certainly heading back to the Supreme Court within the next few years. And when it does, this unanimous ruling will be central to the analysis. What comes next? This 9-0 decision just provided the clearest guidance on Second Amendment interpretation that we've had in years, and the next 12 to 18 months will determine which state-level gun restrictions survive and which ones fall. Federal courts now have unified frameworks for evaluating these statutes, and that framework is already reshaping litigation across the country. If you want to stay informed about every major development in Second Amendment law, every court ruling that affects gun rights, and every shift in how these constitutional questions are being decided, make sure you like this video and subscribe to Firearm Legal Briefing, because this legal landscape is evolving rapidly. Drop a comment and tell me which category of gun statute you think is most vulnerable under this new framework. I'll see you in the next one.